We are recording.
Good morning, everyone. Welcome to the appellate court. I'm Judge Bright. I'm sitting this morning with Judge Albert and Judge Alexander on the matter of MALINOWSKI versus SIKORSKY Aircraft Corporation, AC docket numbers 43617. We are conducting this argument over the Teams platform, which means everybody's appearing by video conference. In addition, the matter is being streamed live on the branch's YouTube channel, and the recording of this argument will be posted on the branch's website. To the extent there is any protected information involved in this case, it should not be disclosed. I remind counsel to be careful not to disclose such information. I'm going to ask everybody to introduce themselves just to make sure we can hear and see each other okay. I'll start with the judges, then counsel for the appellant, then counsel for the appellee. And I'm Judge Bright.
I'm Judge Albert.
Good morning, Judge Alexander.
Good morning. I'm Attorney Lucas Strunk for the appellant.
Good morning. I'm Attorney Donna Civitello for the appellee.
All right. I can hear and see everyone okay. I assume that's true for everyone else. I'm going to ask anybody who's not talking to mute their microphones to avoid any feedback or background noises. So, Attorney Civitello,
yes.
There should be on your screen, you should see a microphone. You just click on that. That will mute your microphone.
Okay, thank you. I was just checking because I am getting feedback.
Right. So mute your microphone, and that should stop that. Same thing, Attorney Strunk. You can mute your microphone.
Yes, I will, Your Honor.
Okay.
Do we mute everyone, Your Honor, where it says mute all?
No. There should be a microphone icon on the top or bottom of your screen. Just click on that microphone. There you go. Okay. All right. So if at any time during the argument you cannot hear anyone, please let us know. If you cannot see anyone, please let us know. If you get disconnected for whatever reason, please go back to the link and click on it to log back in. We will suspend the argument until we know that everyone is present. As I discussed, we're going to ask everyone to keep their microphones muted when they're not speaking to avoid feedback and avoid background noises. The judges will similarly do the same, and if we have questions, we will raise our hands and ask counsel to recognize us. If you don't, we'll jump in like we would in the courtroom, but again, we want to try to avoid the background noises and the feedback. And while I want you to keep your microphones muted when you're not talking, please keep your camera on at all times so that we can make sure that you're present and appropriately engaged in the argument. I'll remind counsel that although we are doing this remotely, this is a court proceeding, and we expect everyone to behave like they would if they were standing in the courtroom here in Hartford. Each side will have 20 minutes to argue. The appellant can reserve time for rebuttal. I'm going to keep the time because we don't have our light system. I will hold up signs when you have 2 minutes, when you have 1 minute, and when your time is up. And with that, I think we're ready to proceed. Attorney Strunk, are you ready to go?
Yes, I am, Your Honor.
Okay.
May it please the court, I am Attorney Lucas Strunk, and I represent the defendant, SIKORSKY Aircraft Corporation, and its Workers' Compensation Administrator, AIG Claims. I would like to reserve 5 minutes for rebuttal, Your Honor.
All right, you're all set.
By way of introduction, I would note this is an appeal in a workers' compensation matter from both the decision of the trier and that of the Compensation Review Board, the CRB. This is a case that requires analysis of the basic elements of proof in a repetitive trauma claim involving an internal injury, in this case, osteoarthritis of the left knee, and in the setting of a prior injury. It's well established that the claimant plaintiff has the burden of proof to establish that his employment was a substantial factor in causing the need for a total knee replacement. It's also equally established by our courts, and as referenced in our brief, that in the case of internal injury, in the face of a pre-existing condition, competent medical opinion is necessary, and that medical opinion must be expressed with reasonable medical probability. It's these basic elements guided by our case law that provide order within our workers' compensation system. In analyzing this case, I would ask the court to note that this is not a case of a gentleman who worked 27 years and wore out his knee. This is a case in which almost 40 years prior, the gentleman underwent a surgery to his left knee that removed his medial meniscus. And there's no doubt that that surgery led to a significant osteoarthritic change. So this is not a broad brush case. The medical opinion needed in this case to establish compensability required that the work activities be a substantial contributing factor to the worsening or acceleration of those osteoarthritic changes. Let's go right to the ultimate finding by the commissioner relative to the left knee total knee replacement. The commissioner found that the claimant's repetitive activities of climbing up and down stairs while carrying heavy parts and fixtures, setting up a grinder while reaching and leaning on one foot, extensive pushing, pulling, reaching, and lifting of heavy parts acted in substantially and permanently aggravating his underlying and pre-existing left knee conditions, resulting in the need for a left total knee replacement on February 19, 2015. And although he cites to Dr. Perret never articulated that opinion. Dr. Perret never used the word permanent. It's not in the record. There's no reference to acceleration. There's a disconnect between the commissioner's finding and the opinions of Dr. Perret. That results in an improper inference. That's error by the trial commissioner. Absent direct testimony by a physician, the commissioner resulted in speculation and conjecture. Why is it in this case that there's a lack of competent medical opinion? We would submit that there's a lack of competent medical opinion expressed with reasonable medical probability. The cases we've cited, Kincaid, Murchison, all highlight the need for direct testimony based on reasonable medical probability. We would submit that at best, Dr. Perret had a superficial knowledge of the claimant's work activities. He certainly didn't address the various activities that the commissioner cited in his conclusions. We're aware that the Struckman case says that there's no particular magic words when expressing an opinion with reasonable medical probability. And we're aware that the case law directs us to look at the whole of the opinion in attempting to judge probability. We submit that if you do look at Dr. Perret's opinions, it's probable that the overwhelming issue was the extensive arthritis due to the prior meniscectomy. In fact, Dr. Perret's final comment on the need for the total knee replacement says that this obviously dates back to a 1973 meniscectomy, 11 years before the claimant ever came to work at Sikorsky. The best that can be gleaned from Dr. Perret's record is that there's an undefined aggravation, likely causing some swelling. But there's absolutely no comment on altering the progression of the osteoarthritis. It's that permanent aggravation, that acceleration of the osteoarthritis, that's key to the opinion on compensability.
Attorney Strunk?
Yes, Your Honor.
Can you mute? We're probably going to have to take turns muting our microphones because I'm getting feedback. So if you can mute your phone while I ask the question, or mute your mic. There you go. Okay. So do you agree that even Dr. Alina says that work was a contributing factor to the need for surgery?
Yes, Your Honor. He said it was a contributing factor, but not a substantial contributing factor, expressing a distinction in terms of proof.
And did Dr. Lena describe during his testimony what he meant by significant contributing factor, or it not being a significant contributing factor?
No, I do not believe he did, other than to look at his testimony, which indicated that he was actually surprised at how long Mr. Malinowski went before needing a total knee replacement. Remember, this is almost 40 years from the original surgery. Dr. Lena indicated that he would have anticipated the total knee much sooner in time, given just the passage of time and the nature of the original procedure. So in that context, I think the doctor was explaining why he didn't think work was a substantial contributing factor, and that it was, in essence, coincident with his employment.
So the swelling, do you dispute that that work was a substantial contributing factor to the swelling that occurred in 2012?
No, I think it's pretty clear that the two 12-hour shifts resulted in swelling of both of this gentleman's knees. But there's no comment that that swelling in any way caused an acceleration or permanent aggravation of the underlying osteoarthritis.
So your issue is a lack of a link between the swelling in 2012 and the need for the knee replacement in 2015.
That's certainly one of the issues, Your Honor, yes.
Thank you.
I was about to discuss a case which I found very interesting that the Compensation Review Board didn't refer to, and then also the classic Supreme Court case. The first is Avino versus Stop and Shop, and ironically, the other is Glenn versus Stop and Shop. Both of those cases illustrate competent medical opinion in addressing cases of repetitive trauma in the setting of degenerative changes. And both of those cases emphasize the importance of the physician commenting on all of the work activities, illustrating an understanding of the work activities. Dr. Perret seemed to focus primarily on Mr. Malinowski's moving of parts in the 800 to 1,400 pound range, which we submit he didn't do on a regular basis. And Dr. Perret makes no mention of the fact that Mr. Malinowski had mechanical assistance in moving those heavy parts. The definition of competent medical evidence is not that there's any evidence at all. It's that there's evidence on which the trier can properly rely and from which the trier may draw proper inferences. And I would direct the court's attention to Dengler and Metall. There's evidence in this case, but the defendants submit that it's not competent medical evidence, taking into account the instruction that the courts have given us in cases like Glenn v. Stop and Shop, Dengler, and Metall. We submit that the Compensation Review Board recognized the deficiencies in the medical evidence. To quote them, I think it was, they viewed it as the limitations in the medical evidence. And as a result, they shifted to an attempt to use the Garafola line of cases, the so-called common knowledge line of cases. We believe there's multiple errors in the board's attempt to uphold the commissioner's finding on that basis. First of all, most recently, the court in Bagley defined for us the common knowledge exception, saying that it focuses on well-substantiated facts obvious to the general community. Whether acceleration of 40-year-old osteoarthritis after a total meniscectomy, and whether that's been accelerated by a job, is simply not widely known. That's not something that the common man can address. Again, it's a case here in which the board didn't recognize its own precedent. in Garofalo versus Jarvis, which is a repetitive trauma knee claim, in which the board viewed the case as a complex case and looked at the opinions of the treating physician, in that case, Dr. Cambridge, for a reasonably medical probable opinion. Garofola, remember, was a case of no pre-existing condition, repetitive lifting resulting in a back sprain. And the court said, well, we can see how that would happen. There's no other known cause. There was heavy lifting, pulling this mold, and a back sprain developed. That case is nothing like the instant case that's before you. Secondly, the common knowledge exception applies only when there's no other known cause. In this particular case, we know that there's a surgery 40 years prior that has caused this osteoarthritic change. So by definition, we have another potential cause, and therefore the common knowledge exception cannot apply. I think it's important as well to address two other concepts raised by the board and the plaintiff. One is the misapplication of the language in Murchison. It seems to be suggested that the medical opinion of the doctor should be taken in concert with the other evidence in the case. And I think the suggestion is you could have an inadequate medical opinion and somehow bolster it with the other evidence. I don't believe that's the case at all. I think in essence, what we're looking at is a medical opinion that is expressed with reasonable medical probability, and then the commissioner or the trier or the court looks at the foundation of that opinion and whether the other evidence supplements that opinion. Otherwise, you would create an incredible amount of subjectivity within our system. You could take a doctor could say, well, it could be related to work. And then the commissioner could look at all the other evidence and say, well, you know, there was a lot of activities. I think, therefore, this is compensable. I think that's specifically what competent evidence attempts to avoid. The Mittal case is an example of that. That's a case in which one of the doctors said it could have been. There was clearly exposure at work, but the court didn't reverse a prior finding of no causal relationship. To the extent that there was a motion for articulation in this case, I will rely on my brief. I think it's important that the court perhaps make a comment on the importance of trial commissioners responding to motions for articulation, particularly when a commissioner finds a permanent aggravation and there's no evidence in the record of permanent aggravation. In summary, the court here erred, the commissioner erred, in resulting in speculation and surmise by not having a direct medical opinion expressed with reasonable medical probability. The board's attempt to save the commissioner's conclusions were equally flawed because of the misapplication of the Garofola exception. I thank you.
Okay, so you will have 5 minutes left for rebuttal. Attorney Civitello, are you ready to go?
Yes, Your Honor, I am. May it please the court, my name is Donna Civitello. I represent the plaintiff, Richard Malinowski. In response to Attorney Strunk's argument, I'd like to start with the law of Connecticut, which has been the law since pretty much the inception of the Workers' Compensation Act. And I'm referring to the treatise, the Westlaw Practice Series treatise on Connecticut workers' compensation that I am fortunate enough to have written with Attorney Strunk and three other attorneys. When we talk about causation in the first chapter, we write about the triggering of symptoms by workplace events for pre-existing medical conditions. So what we write is that causation may be established where the accident or conditions of employment have exacerbated a pre-existing condition, precipitated a condition such as stroke or osteoarthritis, or accelerated a pathophysiological process such as degenerative disc disease. Underlying all these factual variations of causation is the basic test, even if unarticulated. Was the work-related incident or activity a substantial contributing factor to the employee's condition, need for treatment, permanent impairment, wage loss, etc.?
Attorney Civitello, what was the work-related incident here?
The work-related incident was 3 days of heavy repetitive trauma prior to and including January 12th, 2012, where the claimant pushed and pulled heavy racks of gears for 3 12-hour shifts and immediately had onset of severe pain and swelling that did not abate despite consistent conservative treatment for 3 years. That was the immediate period of repetitive trauma. However, the entire period of repetitive trauma, beginning from the claimant's initial days at Sikorsky, is also relevant to this claim. The claimant doesn't dispute that he had pre-existing degenerative osteoarthritis resulting from his prior meniscectomy in 1973.
So I'm just a little confused. It's your position that the you're trying to align this with, I believe, the Linden Tree case, where those 3 days where he sought overtime because nothing was going on in his department and he went to a different department where there was lots of business, and he, for 12-hour shifts, pushed a heavy cart around or something similar to that. That is much like the worker in the Linden Tree, I think that's the name of it, situation where the worker lifted heavy wood and threw out his back. Is that what you're saying? Just those 3 days did it?
No, Your Honor, if I may. The entire period, the claimant
and where in the commissioner's decision is what you're saying, please?
Okay.
Also, while you're saying, if you could just point me to it. Thank you.
Yes, I will. It is finding C, which is at the defendant's appendix, page A7. Because, Your Honor, the repetitive trauma is not limited to 3 days. That was the inciting event. But as I will outline the testimony for you, his work was extremely heavy over 28 years. For the first 26 years working on 2 Springfield machines, and then working in the gear cell for the last 2 years. Now, the work over the last...
I don't see those 3 days in finding C.
Because the commissioner's talking about repetitive trauma, repetitive work activities.
I asked you what the event was. You told me it was 3 days of overtime. It's not in finding C.
Commissioner, it's in the medical evidence, and the commissioner doesn't have to.
Okay, so it's not in finding C. I'm just trying to
okay,
add a little rigor to this discussion. Okay.
Okay. So if I may, the issue for the commissioner to decide was whether the plaintiff's work activity over 28 years at Sikorsky, up to and including the 3 shifts, 12-hour shifts of very heavy labor in January 2012, aggravated the pre-existing asymptomatic osteoarthritis disease, so causing it to become symptomatic and require treatment, including a knee replacement, where no treatment had been necessary for 39 years. In this case, the facts support the treating physician's opinion that the knee symptoms that began in January 2012 and continued unabated until the knee replacement 3 years later was caused by workplace aggravation of pre-existing degenerative arthritis. So if you start with the commissioner's findings, the commissioner found Dr. Perret's testimony more persuasive than that of the defendant's expert. And we did just go over the commissioner's finding on compensability, finding C. Dr.
I
Perez,
have another question, please. Dr. Perez, in February 15th, 2012, stated, I believe the plaintiff's overwhelming issue is the arthritis. He had a previous meniscectomy medially and essentially has no meniscus left. And then November 27, 2012, in another office note, Dr. Perez, the plaintiff's original injuries on the left side occurred when he was working for the Honda driving the motorcycle, and subsequently now arthritis has developed. How are those findings at all related to his strenuous work? I'll grant you that the work he and his co-employees do at Sikorsky is strenuous. How does that get tied up?
well, Commissioner, there's a statute in the Workers' Compensation Act, 31349, which requires an employer to be responsible when a claimant has a pre-existing condition such as this, which was a severe case of osteoarthritis. The employer is responsible if the work materially and substantially aggravates the condition, which is what happened with the claimant's employment. So
And what doctor stated that?
Dr. Perez.
And where is that, please?
Dr. Perez, his opinion dated January 19th, 2012.
Okay, can you just give the appendix site to that, please?
Yes.
Or you have it? Yeah.
Would you like, hold on one second. It's A236. I'm sorry, I may not be able to find it quickly.
So A219, I think, is the first. That's the February 8th, 2012.
Yes.
Great.
The responding, I'm sorry, this is not included in the defendant's appendix. It's included in Exhibit C to the formal hearing. I'll have to read it to you if that's acceptable. He said, this is a work injury. He previously does have substantial damage to the knee from a previous injury, although he had bilateral knee arthritis. At this point, the effusion is rather significant. I believe it was caused by his work-related efforts, pushing very heavy racks of gears, working 12 hours a day for several days in a row. He has moderately severe degenerative joint disease, which has been aggravated now by his work-related injury.
Right. So that's if I could, that goes back to the question I asked Attorney Strunk. It seems to me that Dr. Perez connects the effusion or the swelling to those 2 or 3 days of working 12-hour shifts. But where does Dr. Perez connect the need for the surgery to a work-related condition?
He does in his medical report. Let me just find it. I'm sorry, did you ask if he connects the swelling to the need for surgery?
Correct. So we have these 3 days where the swelling occurs, but where does he say that these, because he says the swelling in another report was the result of an ACL tear and of other ligament tears. But as I understand, the need for the replacement had to do with the fact that the claimant was bone on bone in his knee. So I'm trying to figure out the connection between the effusion or swelling that happened in 2012 and the surgery that was required in 2015. Well,
Commissioner, in the medical records for Dr. Perez, which are in the Appellee's appendix at pages A22, beginning at A22, document continuing swelling for 3 years, document the doctor having to drain the effusion repeatedly, and also the need for injections. So the knee became symptomatic. The swelling, which had never been there before, manifested after the 3 days of repetitive trauma. Does that answer your question, Your Honor?
I think so. I'm just getting to A22. So this is the March 14th, 2012 note.
All right, so we're starting with A22.
So we're still in 2012 where he still has swelling.
Yes, so on March 14th, which is page A22, Dr. Perret recounts previously aspirating an infusion today, and today he has a reaccumulation of that same effusion that he had 2 weeks ago. The effusion was drained, he had an injection, and this repeats throughout the pages of Dr. Perret's treatment. He's still very sore. He's been taking Percocet. He's considering surgical intervention. So the 3 days precipitated the medical treatment where there had been none before. And that's what the Act provides for. You take a claimant as you find him with all of his pre-existing infirmities. That's what this case is about.
Okay, thank you.
So Dr. Perret's opinion is expressed again in December of 2016. He addresses both knees, but the left knee in that opinion, and that's where, Your Honor, he talks about the ligaments that are damaged. He was referring to the right knee. He says that the right knee is solely and exclusively related to Sikorsky aircraft working history, and the left knee is related to a Honda workers' comp injury and then subsequent aggravation working at Sikorsky aircraft. The defendant tries to undermine these opinions by saying that Dr. Perret was unaware of the plaintiff's actual work duties, but the plaintiff testified on 2 occasions that he told Dr. Perret about his work duties at pages A170 of the defendant's appendix. You can see that testimony. And again, in his deposition at page 51, where he twice testified that he told Dr. Perret about his work duties. And he specifically said, I did tell him I pushed a lot of weight, did a lot of climbing at work and leaning over. So the defendant tries to undermine Dr. Perret's opinions by complaining that they're unsupported by the facts and evidence. What the commissioner found regarding the work duties was that in paragraph 1R of the findings and orders, the plaintiff had to use a pallet jack to move the Blackhawk fixtures. And I just want to make sure everybody understands what a fixture is. It's a tool that gets affixed to a gigantic machine, and then machine parts are made using that tool. So the Blackhawk helicopter fixture weighed up to 1,400 pounds for many years and then went down to about 500 pounds. The claimant moved that 100 yards, which he did when he had to, but he only did that 20 to 30 times over his career at Sikorsky. But in addition to that, 2 to 3 times a day, the commissioner found 2 to 3 times a day, depending on the job requirements, the plaintiff had to move with a pallet jack heavy fixtures that were stored directly across the aisle from his machine and position them for the crane to pick up. That's a finding. And the other relevant finding, that was at 1S, paragraph 1U of the findings, is that the plaintiff had to push around carts with heavy parts on a regular basis. Well, what's the evidence in the record to support this? The claimant's testimony, which was not challenged or refuted, in which the commissioner found credible and persuasive. I'll refer to his deposition, which the commissioner had before him and in evidence. The claimant did the same job for 26 years on the Springfield grinder machines, and then for 2 years prior to January 2012, he moved to working in the gear room. When he was working on the Springfields, you can see his testimony at page A153 of the defendant's appendix, that he would pick up fixtures weighing from 800 to 1,400 pounds from the fixture crib, put them on a pallet jack, and pull them 70 or 80 yards around turns. After he set up the fixture, he had to get the parts, which are different from fixtures. They weigh up from 800 to 900 pounds. and he brings them in a pallet jack to the aisle where his machine is. That's at Appendix 155. That's an everyday thing for the plaintiff when he works on the Springfields. So here defense counsel asks, now you said you would move around 600 or 700 pound parts with just a hand truck. And the plaintiff affirmed, yes, a hand truck. Question, one person? Answer, that's it, at Appendix 156. The defense counsel in the deposition expressed the same misunderstanding that the defendant continues to assert even to this argument and should no longer. There were two kinds of pulls. There were the pulls that the claimant only did 30 to 40 times at most during his entire career at Sikorsky, which was pulling fixtures for the Black Hawk helicopter from a crib, a fixture crib, 80 to 100 yards away. Those fixtures weighed 1,400 pounds. Those weren't the only heavy things he had to pull. Every day on a regular basis, he pulled fixtures and parts from across the aisle, 20 to 30 feet, he testified, and those parts weighed 800 to 900 pounds. Here's the testimony. Okay, this is at page 1A57, I'm sorry, Defendant's Appendix A157. Question from defense counsel. Okay, when you said you did it 30 or 40 times, that's over the course of your career. Answer, yes, I made the pull from the fixture crib. I was constantly, once or twice, 3 times a week, making that pull from maybe 20, 30 feet away across the aisle to pull the fixture out, rotate it, locate it, pull it up on the crane so that I can get it up on the machine because it was stored across from me sometimes. Question, you said 2 to 3 times a week, but then you said 30 or 40 times over the course of your career. The numbers sort of don't add up. Answer, the 30 and 40 times was the pull from the fixture crib, which was located 80 to 90 yards away. That was the long pull, you know. That was a heavy pull, and there were also other fixtures that were in the housing cells that were 1,000 pounds. We made those pulls too. We didn't do it all the time, but it had to be moved. They were moved that way. And what did you call it? Question, and what did you call it, the crib? Answer, the fixture crib. Yeah, that's where they kept all of the fixtures for all of the parts. Question, would you say that you did those type of activities pretty consistently during the course of your 26 years? Yes, yes. And on the next page, he talked about what he did every day.
Attorney Civitello,
Yes.
I hate to interrupt you. I'm looking at the commissioner's opinion, referring to your client's testimony, line M. Between 1973 and 2012, he had occasional soreness in his left knee after strenuous exercise such as running, swimming, playing basketball, but no swelling. How do you square that up, that he seems to be doing swell with accommodating the job and his hobbies of running, swimming, and playing basketball with your information now that over the course of his career, he was doing work activities that no one with zero meniscus in his left knee should ever be doing?
Your Honor, Dr. Lena answered that question.
Well, no, this is how do you square up this is, you were giving us information from your client's testimony, and I am looking at your client's testimony as recorded by the commissioner.
Your Honor, osteoarthritis, as Dr. Lena testified, can be completely asymptomatic, and then something will set it off and it will become symptomatic. And that's what happened in this case. This claimant had a gradually degenerating knee. The repetitive trauma of everyday work was accelerating the aggravation.
Well, it doesn't say, Dr. Perez says severe degenerative arthritis. It doesn't say gradually degenerating knee.
Your Honor, I'm out of time, I'm told.
Well, you can answer the question.
Okay, thank you. You take the opinions as a whole. Dr. Perez clearly expressed multiple times that there was an underlying severe degenerative condition that became symptomatic and was aggravated by work.
Okay.
Thank you, Your Honor.
I do have one other question for you, which
Yes.
is Do you agree that it was that the board should not have applied the common knowledge test?
Yes, I do agree emphatically, Your Honor. I believe that case is completely inapplicable to this one because there was competent medical evidence. They did not rely on common knowledge.
Okay.
Thank you.
Attorney Strunk, you have 5 minutes for rebuttal.
Thank you, Your Honor. Just for the record, the quote relative to the substantial damage to the knee from the previous injury that was read by Attorney Civitello is in the appendix at A219. I think, you know, we can get bogged down in the debate as to how often Mr. Malinowski moved heavy parts. The commissioner made a finding at A4 of the appendix, his paragraph R, as to how often, based on the evidence, he thought Mr. Malinowski went and made that long pull with the heavy part. But the bottom line is that's neither here nor there, because as Attorney Civitello just argued, she's asking you to take Dr. Perret's opinion in the whole. And that's the broad brush that I'm talking about that should not be applied. We need to look at the specifics of the opinion, competent medical evidence based on the history, and an opinion expressed with reasonable medical probability. I think Judge Bright's question is also on point to the extent that there is swelling in 2012. The appendix reflects the treatment and the nature of the problem in 2012, but as Your Honor pointed out, 2615, Mr. Malinowski is back. His left knee is physically examined. There's reference to the old, there's no redness, there's no induration. And the doctor says the range of motion actually remains fairly good. And then he goes on to say that Mr. Malinowski is now considering a total knee on the left. He's strongly considering surgical intervention. And in my opinion, this obviously dates back to his 1972 open meniscectomy. You know, he makes a reference to AIG, which is incorrect, but he's talking about the original compensable injury where Dr. Campbell Jacobs did surgery back in 1973. That's an opinion expressed by the treating physician, which cuts back against what the commissioner is ultimately trying to find with respect to permanent aggravation or acceleration. And I'm sorry, Judge.
Was there evidence presented that after the onset of the swelling in 2012, he got no relief in the condition of the left knee from 2012 until he had the surgery?
I would have to defer to the record, Your Honor. Off the top of my head, I have the impression that it quieted down. I think that 2015 report evidences that it quieted down.
Well, that's referring to the right knee, I think. I think the part you're referring to where it looks good and the range of motion is good is referring to the right knee post-surgery. But
I apologize if I did that. Well, it does say physical exam on the left knee indicates that's 234 in the middle of the page. I'm hesitant to cite our treatise to the court because we're both contributing authors to that treatise, but I would emphasize that clearly the work did not precipitate the osteoarthritis, and clearly there is the concept of permanent aggravation and acceleration in cases like this, as evidenced by the case law. And there's no evidence of acceleration opined by Dr. Perret, nor is there an opinion regarding permanent aggravation of an osteoarthritis. Thank you.
I had one other question for you. Attorney Civitello said that Dr. Lena testified that osteoarthritis can be asymptomatic and then triggered by some event. Do you agree that he testified to that?
I think he testified that there was a natural progression. I do think he attributed the swelling to the osteoarthritis. I don't recollect his other testimony on that particular point.
Okay.
I thank the court for the opportunity this morning.
All right. Thank you both for participating in the virtual courtroom. It's an interesting case with interesting facts. We will take the matter under advisement, and we will stand in recess until 2 o'clock this afternoon. Have a good day.
Thank you, Your Honor. Thank you.
Thank you, Your Honor.